Welcome everyone to a Tuesday afternoon lunch and learn. I'm Nicole Davidson. I'm a commercial mediator. I'm a negotiation trainer and negotiation advisor. And I'm going to be talking to you today about some key techniques to improve your mediation and negotiation outcomes. I have a presentation which I'll bring up in a second. I do encourage you though to feel free to unmute and interrupt and ask questions at any point. Very happy to run this, although there are a lot of people on the call, but very happy to answer questions as we go through and make this a little bit conversational. Otherwise, if you have questions and you'd like to add them into the chat, I've got Emma from Clarence here who's going to be monitoring that chat, and she can let me know if there's any questions I can answer as we go, and I'll try and leave some time at the end. And I would like to thank Clarence for inviting me to speak to everyone. It's a real pleasure to be able to talk about something that I love and am passionate about, and hopefully will help you in your roles as well. So let me just pull up the slides and we'll get into it. Okay, so a little bit first about who I am and why anything that I have to say about this topic might be useful for you to understand. So I am, as I said, a negotiation specialist, a commercial mediator. I've been doing this, I've been accredited as a mediator since 2015. I've been teaching negotiation and general communication skills since the mid-2000s. Prior to that, I spent about 10 years working in law. I completed my articles, but then actually left before I had a practicing certificate for various reasons. But I did spend the rest of that sort of 10-year period as an investment banking analyst in insolvency, working for insolvency practitioners, including on the ANSET administration, and spent a little bit of time as a recruitment advisor as well. So quite a varied background, and that's the sort of experience that I bring into the negotiation work that I do now, because I've come across quite a few industries. So now what I do is as I said, I do the commercial mediation work, whether that's within the context of litigation or pre-litigation. I also do negotiation advisory work where I'll help a particular client on their side of the negotiation rather than that independent neutral, and I do a lot of training work. So it's an area of passion for me. I really believe that if we can have better conversations in the workplace, we can get much better outcomes and we can save everyone a lot of time, stress and money. So I'm passionate about spreading the word, and hopefully some of the tips that I'm going to share will help you to get those sort of outcomes for your clients. So what we're going to talk about today is all based, a lot of the training work that I do is all based around the Harvard 7 Elements model. And for those of you who haven't come across that, it was first published in the book Getting to Yes by Roger Fisher and Bill Urey back in the mid 1980s. And basically they said, after studying a whole range of negotiations in all sorts of different contexts, you know, from political to personal to business, international, local, you name it, there's 7 things that come up in every negotiation, regardless of its context. And it's by understanding what these 7 things are, using them to plan more strategically before you get into a negotiation, and then recognizing which of these elements is at play when things get difficult, that will allow you to deliver better negotiation outcomes. Now, I talk about this, and some of you might have heard of interest-based negotiation versus sort of distributive or adversarial negotiation, and it's very much this style. That being said, I'm not all about purely interest-based negotiation as the sole focus. There is a time in every negotiation where you have to get distributive. So distributive negotiation is that sort of win-lose mentality. Every dollar extra I get is a dollar less for you. Interest-based is more about let's create as many dollars as possible and then split them. Now, you will ultimately, ideally, start a negotiation in interest-based mode, trying to find as much value for each party as you can, but ultimately you're going to have to come down and use distributive techniques to claim the most of that value for your particular client. So I'm going to give you a bit of an insight into how this all works and some key tips and areas where I see things going wrong in the mediation work that I do. Now, the 7 elements I'll just go through really quickly to give you a bit of an idea. The first of those is relationship. So every negotiation will be impacted by what the parties think of each other. You know, do they have a positive perspective of the other person? Do they have a negative perspective? Do they trust them? Do we have the right people in the room for the negotiation at all? So that element of relationship plays in, and I'm going to come back and talk about each of these in a little bit more detail soon. The next element is communication. Every negotiation is a communication process, whether we're communicating verbally in a conversation, whether we're negotiating via email, text messages, anything you like. We need to be communicating clearly. We need to be on the same page. So when I've said something, have you actually understood it the way I have intended it, or has there been miscommunication going on? And what can we do in the process of the negotiation to ensure that the communication is as effective and clear as possible? Because one of the things I see is a lot of disputes come from a place of miscommunication and misinterpretation of things that people have said. Going into what we're actually going to be talking about in a negotiation, the key element here is what we call interests. And this is really what are the motivations of each of the parties. Not what do they want, but what are they trying to achieve through this process? And once again, we'll see when I go into more detail that this is often one of the stumbling points in negotiations. So we'll look at how we can avoid that being so. We also have in every negotiation this idea of options. There will be a number of things that can be agreed to by the parties to solve the problem that they're at the negotiation table with. Once again, at a very high level, one of the problems is often that we jump to the very first option that comes up that is acceptable to both parties. It's often not always the best option. So we'll look at that in a little bit more detail. We then have standards, which is how do we justify various options that are being discussed in the negotiation? So for lawyers, this is a really easy one because the biggest standard that we rely on is the law. You know, I'm going to say that you've got to pay me this money that's due under the contract because there's a signed contract. This is what it says. This is what the law around contract says. Therefore, the answer is clear. And that works really well, except that in litigation and legal disputes, the problem is often not what is the relevant standard, but the fact that both sides interpret that standard differently. So we'll look at some challenges around that and how to manage them. We then have two last elements, which is really about what happens at the end of the negotiation or what could happen outside of the negotiation. The first of those elements is alternatives. And that recognises that although you and I might be at the negotiation table together and we're trying to do a deal that's going to meet the interests of each of us will have things that we could do by ourselves to meet our own interests. So alternatives is saying, if we can't get to an agreement, what is it that I might do to meet my own interests, and what is it that you might do to meet your interests? And that becomes really important because it tells us, firstly, when it's a better idea to walk away from the negotiation than to keep negotiating. It also sets the boundaries as to who might have the most power in the negotiation. So we'll look at that dynamic a little bit more as well. And then the final element is this element of commitment. So this is where it's pretty clear that at the end of a negotiation, we want to get generally some sort of agreement, whether that's a signed written document or it's just something done on a handshake. We want to have a clear commitment. So we'll look at some of the problems that go on with that. We'll look at also where else we can use commitments to get us to a great negotiation outcome. So that's where we're headed. And as I said, please feel free to interrupt and ask questions as we go through. So looking then a little bit more at what can you do in your negotiations, how can you use these 7 elements? So the first idea here is this one of relationship. Now, when we talk about relationship comes generally from the assumptions that we make about others. And I often think about a negotiation that I had earlier on in my career. I was probably only about 5 or 6 years out of uni, still a bit young and naive and not as experienced as I am now. And I was negotiating as part of the administration of Ansett Airlines. Now, I was working on the team at Ansett that was managing the aircraft fleet. So we had some very expensive assets that also turns out are very expensive to maintain their value. If you don't keep servicing the aircraft, even though they're not flying, you will lose your certification, and then that plane becomes grounded and can't be flown. So there was a lot of work that was needed to be done on the aircraft. even though they weren't flying, to keep their value from declining. Now, there was a big negotiation that had to happen around that as to, was it going to be the administrators who I was representing who were going to pay those fees, or was it going to be the financiers who actually owned the aircraft and were coming eventually to reclaim those aircraft? And when I talk about maintenance costs, I'm talking about some of these. If you had an aircraft that needed a full overhaul, you're talking about $10 million. If your engine needed an overhaul, that was about $4 million. So we're talking some fairly significant costs. Now, I was about to go into a negotiation, luckily not by myself. I had a senior person there with me, and we were going to be negotiating with another insolvency practitioner who was there representing the financiers. I had been told by one of my colleagues, when they heard who was coming in to negotiate on behalf of the financiers, they said to me something like, I can't believe they've sent him in. Prepare to be whipped. He will beat your butt. Something along those lines. Now, if you go into a negotiation and you are expecting something like that, it's not going to be great for your mindset going into the negotiation. And for me, that was a real concern. You know, how do you stop yourself from being impacted by fear? How do you stop yourself from feeling overly nervous so that you can't perform in the negotiation? Now, I didn't have the answers then, but now when I'm working with people, the idea is, what different story can you tell yourself to make that an easier position to deal with? So rather than going, oh my God, I'm going to be attacked, I've got to be defensive, I might then become a lot less interest-based in my conversation because I'm protecting myself. If I can tell myself a story about, look, this is going to be a tough negotiation, I'm going to have to work, but I have to be prepared maybe to stand up for myself. If I can tell myself something that changes my mindset to reduce the fear, then I'm going to be much better off in the negotiation. So the other thing to think about in terms of this negotiation is, have we got the right parties? And once again, it's really important not only to ensure that you've got decision makers in the room. One of the biggest challenges I see in mediations is where someone more junior in an organisation is sent along to the mediation and they've got limited capacity as to what they can agree to. When new information comes up in the mediation, they can't necessarily respond to that because it goes outside of their authority. So making sure that the people in the room at the negotiation have the ability to be flexible, or at least have access to those decision makers at the actual client who can be flexible, is really important. The other thing, though, is the dynamics. So I did a negotiation or a mediation last year between two organisations in the education sector. The managing directors from both business were coming to the mediation. The lawyers for one of the sides said to me there was a real difficulty between those two parties. They basically hated each other. They'd been in conversations through the negotiations prior to mediation where they'd been yelling at each other. It was all very unproductive. It turned out that the chairman of the other side had had some very civilised conversations with their client. And so we decided that it would make sense for the mediation to have both the managing director and the chairman of that mediation of that company present at the mediation, so that we could manage the dynamics of the mediation. And that really did help on the day, because one of the things that we did through the mediation was actually put the chairman in a room with the managing director of the other company, and the two of them had a one-on-one, which was really important in actually moving them to a settlement. So really taking some time to understand the dynamics of those relationships becomes very important in preparing for the mediation. I think the other thing it's important to talk about in terms of thinking about dynamics of a mediation is, have you picked the right mediator for your dispute? And I can talk a lot about choosing mediators, but in summary, I think what the situation can be is that when I talk to lawyers, their choice of mediator is generally done on the basis of someone that they've used before and have been comfortable with, or if they haven't used anybody, it will be a recommendation from others. So we do rely very heavily on word of mouth to find the right mediator. Now, there are different styles of mediation. Some mediators you will find are more evaluative. They're more willing to give you an assessment of what the outcome might be if this matter goes to trial. They're more willing to start telling the parties what they should do. Others are what we call more facilitative, and they're more likely to be more coaching. They're more about asking questions of the parties and leading the parties to a solution for themselves. Now, there is a time and a place for each style. If you've got a client and you've been trying to get them to settle, trying and they're resisting, but you know that it's not going to be a very good outcome for them to go to court, bringing in that older, wiser, retired judge or QC or somebody with a bit of gravitas who might have a more evaluative style can be a real positive to actually get an outcome in the mediation. If, however, you've got a situation where that's not in question and the parties want to walk away having felt in control of their own choices, then finding a facilitator who's more facilitative, who has a deep understanding of the negotiation dynamics and the psychology of conflict, will probably leave your client with a better experience. And I talk about mediation being not just about getting to a result in terms of an outcome, but it's also for clients to walk away and being able to put that dispute behind them. I don't know about you, but I've talked to a number of people who've been through some sort of conflict, whether it's gone to litigation or whether it's finished beforehand. And it might be 10, 15, even 30 years down the track, and they still wear that conflict. They cannot put it behind them. They're still resentful. They're still upset about it. My mission in a mediation is not just to get an outcome, but to get one that that person can put behind so it doesn't stick with them as a negative experience in their life for the years to come. And I think that really only comes from that facilitative process where people are really brought into the mediation process and really have that sense of autonomy over what's happening to them. And that is one of the big advantages of mediation, is that the parties are able to control the process and manage outcomes. If you've got a mediator who takes that away from them, I think something's lost in the mediation process. So that's what I wanted to talk about with relationship. I'm going to move on and talk now about communication. And I'm not going to spend too much time on this, but there's a couple of key things, once again, that go wrong here. One is that a lot of the time we work on assumptions in negotiations. We will assume that the other party thinks something, or that when they said this, they did it for a particular reason, and we won't always ask. Sometimes that's because it feels like we can't ask. Maybe it seems like it's a bit rude if we're asking about, what their internal thinking is. Other times we just don't even think to ask because we haven't even recognized that we're making an assumption. But one of the things, again, that I see in these mediations is once we start to get to the mediation and we start unpacking some of these assumptions, it can be a real turning point in actually getting to a resolution. So, once again, thinking about how that works in practice, one mediation I did was a defamation case. Somebody had been sued by one of their local councillors for defaming them online. And we were at mediation, mandatory mediation through the Magistrates Court. Now, it was assumed by the plaintiff, who was the counsellor in this case, that the other party didn't want to settle, that they actually wanted it to go to trial because they wanted to get further publicity and they wanted to be able to use that process. What it turned out was, and so they were being very resistant to, hearing any offers or putting any offers forward. They thought that there was just nothing that was going to happen. They didn't even really want to engage in the mediation process. When I sat down in private session with the defendant, it turned out he actually really did want to settle the case. And what he disclosed to me in private session was that he was actually quite ill. He had been diagnosed with cancer. In fact, what he told me at the mediation was that his son-in-law, who was at the mediation with him, didn't even know this yet, but he had a lifespan of about 3 months to go. Now, I can only assume it was true. Maybe it was a ploy, I don't know. But it certainly was a different assumption to what the other party had. Now, I had to work with that to go, what do we do? And we came up with some inventive ways of letting the other party know that they needed to get to a settlement today and that there was real incentive without disclosing his terminal condition. He didn't want the other party to know about that, especially ahead of the rest of his family. So we came up with a way where we were able to disclose that there was a medical concern. I said to the other side, I can't tell you what the medical concern is, but you can start making some assumptions about what that might be and what it might look like. So they sort of went through and they said, well, let's just assume he's got cancer. He's got cancer. It means that the trial is going to be delayed by 6 months. So that's what it means for us. Okay. And I said, okay, well, let's assume it's not that. What could it be? And we went through about 5 or 6 different scenarios, including one in the middle, which was they assumed he was going to die. But I left them to just think about all of these things to factor into their conclusion. And I'm very happy to say that that mediation did settle in the end. One of the other things that we do though, and this is interesting, whether it's in a mediation or whether I'm running hypotheticals in negotiation training sessions, is that we love to talk. We love to tell the other side everything we know and give them all the reasons why they should accept what we've got on the table. The key skill of a negotiator, rather than telling people things, is actually asking questions and learning information. And there's a great little phrase that I use in all my courses, which is we have 2 ears and 1 mouth, and we should use them in those proportions. Why? Because when we speak, we simply repeat what we already know. When we listen, we might learn something new. So a great negotiator will really focus on asking questions, getting as much information about the other side and where they're coming from as possible before they start trying to convince them to do what they want them to do. And it's one of the real skills. And that's, once again, where a mediator will come in, because the mediators tend to be focused on asking questions that sometimes the other parties forget. And of course, once we have asked those great questions, as a negotiator, we need to be very good at listening. And once again, listening, it's easy to hear, it's much more difficult to listen. And often we get things in the way of listening. Maybe it's because we've already decided what they're going to say, or maybe they've started responding and we're now so busy thinking about how we're going to respond to the first thing that they said that we don't hear the second thing that they've said. So there's a whole range of things that get in the way. But if we're going to negotiate well, we need to be better at both those questions and listening. And teaching you to do that is far more than I can do in a 1-hour seminar. So I'm going to move on to the next topic, which is this idea about interests. And once again, this is where, if you want to move away from the conflict and get to a more creative solution, and I take on board that there's not always a creative solution available, but we need to move away from what the people want to why it's important for them. Now, you might be wondering, I've got some weird photos on some of my slides. You might be wondering why I've got a photo of some wrestlers there. So let me enlighten you. This relates to a mediation that I did a number of years ago, and it was a mediation between 2 business owners. They'd been in a partnership together, and that partnership had failed, and the mediation was about cleaning up that partnership and working out some debts and other things that were part of it. And the partnership was a business that had put together a program on professional wrestling. And there was 2 key issues that were at play in the mediation. One was about an amount of money owed and who owed who what. And the other was about the ownership of all of the footage that had been taken while this program was on air. Now, both parties were telling me that they wanted that footage, and it was a sticking point. Neither of them was prepared to give. What I did in private session was ask each of the parties the question, why is this footage so important to you? What are you going to do with it? Now, bear in mind, this was a magistrates court mediation. They'd already both spent about $20,000, which, it's not a huge amount of money, but in relation to what the claim was, it was fairly significant. And they hadn't had a discussion about this. So it turns out that partner number 1 wanted the footage basically just so the other guy didn't get it. He didn't really want it. He didn't think it was valuable, but he didn't want the other guy to get it. It was his sole goal. The other person didn't really care about it, but he said the only issue he had was that he had a new business, and on that website were some clips that had been taken from this footage, and he did not want to have to redo his website. So once we had this information, we were able to get a solution put together where the first partner got to keep ownership of all of the footage, but he gave a very limited license to the second guy to use the footage that was existing on his website. So guy number one felt that he got a win. Guy number two felt that he was, not inconvenienced at all. He hadn't given up anything that was really valuable to him. And that enabled us then to move on to work out the financial elements. But it was only through moving away from what they wanted, which was the footage, to why they wanted it, that we could do that. Now, of course, the other thing we need to think about in our mediations is sometimes the why is not rational or tangible. It is those irrational interests. It is the sense of ego that comes up from our participants. It is the sense of fairness and justice. All of those sort of psychological elements that come in. And sometimes what I'm doing as a mediator is actually helping parties structure an option that will help the person meet their psychological needs, as well as the rational needs. So trying to understand what's going on from an emotional perspective in a mediation, even a business mediation, can be really critical. How do we help the other person save face? Perhaps they've said, I've given, this is my best offer, take it or leave it. And we need to move them away from that. How are we going to do that in a way that actually assists them? Because now one of their interests is in preserving face, because they don't want to be seen to have backed away from that statement that they've made. And there's a whole bunch of techniques that we can do to help that process. So that interest piece is really important in the negotiation. Moving on to the next element, we've got options. Now, as I said before, options are basically all of the possible agreements that you could get to in a negotiation. And once again, the key here is that often we'll get to a deal. And the challenge sometimes is not that we didn't get to a deal, but we did get to the best deal. Now, the classic story that illustrates this comes out of Getting to Yes, where they talk about two daughters splitting an orange. And I'll give you the fast version. Both girls say they want the orange. Neither of them is asked what they want it for, so they each get half an orange. One goes away, eats the flesh of the orange. The other one goes away, uses the rind of the orange to make an orange cake and throws the flesh out. So, once again, the idea is if you'd asked that question why, you would have come up with a much more valuable option where one of them gets all of the flesh and the other gets all of the rind, and they both would have had a better outcome. But so many times in a negotiation, we come up with this sort of mere compromise, just split the orange in half, rather than finding that extra value. So the idea here in our negotiations is really to look back at what are the interests of the parties. How do we come up with something that will work? And, once again, I was doing over the last 12 months or so, I've been doing a lot of negotiations and mediations around commercial rent relief. And one example springs to mind where the parties both had different and diametrically opposed interests. The landlord needed cash. They actually lived off the income from their property. And the tenant needed to defer as much payment as possible because they had no business. Their business was shut down. So there was no way really of doing a payment solution that was going to meet the tenant's needs. But we went back to what are the real interests. And once again, the tenant wasn't concerned so much about how much rent they were paying. They understood that there was some rent relief in place and they were prepared to pay what they could and what they were required to pay, but they needed more time. The landlord was prepared to offer the discount, but couldn't afford to not have cash flow coming in. So we looked at those sort of interests that were at play, and what we came up with is a solution where the tenant agreed to temporarily release the bond to the landlord. So the landlord got a cash inflow that they could use to live off. And then instead of paying deferred rent to the landlord after the regulations finished, the tenant would be paying that money to reinstate the bond bit by bit. So, once again, not an ideal scenario, but better than anything else that we could come up with, because we've gone back to those interests of the tenant. A couple of things to think about in your negotiations when you're testing outcomes. Often we get a bit worried that if we put an option on the table, will be held to it, and we don't get to walk away from that option. So putting things as hypotheticals is a really good technique to use in a negotiation to try and test out options without actually committing yourself to them. So, saying something like, look, if we were to think about using the bond as part of a solution, how could you see that working? You're not putting the option on the table, but you're getting them to start thinking about it, and you're getting some new ideas coming through. The other thing is going back to the parties and saying, look, I know that we've talked about a number of options. You're still struggling in relation to these not giving you sufficient cash flow. How do you see some options that might give you that cash flow? What are some of the ideas that you have? And, really being willing to ask the other party for their input has a couple of benefits. One is they might have had ideas that you hadn't thought about, but you're not saying you'll agree to anything that they say straight up. The other thing, though, is it actually can build a sense of collaboration in the negotiations, because you are deliberately asking for their input and showing a willingness to listen to them. So it can actually help the dynamic of the negotiation as well. The other tool I'll talk about briefly is this idea of MESOs. You'll see on the screen, multiple equivalent simultaneous offers. So what we find often is that people in negotiations, if they haven't been taught about interest-based negotiation, if their expectation of a negotiation is that it's a win-lose battle, they're often a bit reluctant to share information with us. So they might not willingly share their interests. They hold their cards close to their chest so that no information can be used against them, which gets very difficult for us to try and negotiate in that case. So MESOs are a way of putting offers out and getting information back from the response to those offers that helps us understand the other party's interests. So in a MESO, what the idea is you craft 2 or 3 offers which your client is equally happy with. So it could be, for example, if you're talking about negotiating payment terms, look, you can have 100,000 in a month, or you can have 120,000 if you're willing to take it in installments over 2 years. Or you can have 100,000 in a month, plus we'll give you some free publicity and do some other things that are of value to you. So when you put that out there, you say, look, we've got 3 options for you to consider. Tell me which one you prefer and what you like about it. And that will start to give you more information about what that party wants and what's the key interests. And once again, at that point, you're not actually putting hard offers on the table. They're just ideas to think about. The final thing I'll talk about with options is reality testing. And once again, it's really important when people are putting ideas on the table that we go back and we say, okay, well, let's think about that. How's that going to work in practice? What are some of the difficulties that will come up, so that we've actually checked what's feasible and what's not. And once again, I've had mediations where the parties have sort of gone through the process and they've come up with something at the end, but when I start to reality test that, it's clear that it's not going to work. So the idea of reality testing early through the process becomes important. Okay, moving right along. I'm conscious that there's a lot of information in this presentation. So for all of you going, oh my goodness, please feel free to reach out and contact me if you've got questions about any of the things that I'm saying down the track. Standards, I'm not going to spend too much time on standards. As I said earlier, the law is the most common standard that lawyers will rely on in a negotiation. This is the outcome we should be agreeing to because this is what the law says. The only problem is that when we do that, it means that a standard is either right or wrong. One of you will be right, one of you will be wrong. And that's what litigation does. Litigation takes it so an independent judge can go, hey, plaintiff was right, defendant was wrong, or the other way around. Problem is, for your clients, if you're going to base a negotiation around standards, it's pretty expensive, slow, and stressful, because the only person who can definitively tell you who's got the right interpretation of the standards is the judge. So there will be times where, even though the standard is unclear, or even though your client believes that they're right in terms of the application of the standards, if you go back to interests, you can find an interest-based solution that works for your client, even though it's not supported by a relevant standard. And I think remembering that is important. The other challenge that we have as lawyers is that you are all subject. Did you know that you're not perfect? I'm sorry to break it to you, but you all have a number of cognitive biases. These are little shortcuts that our brain takes that helps us get through everyday life, but can let us down in critical moments. So one of the critical cognitive biases that we have around this space is that we're all subject to the confirmation bias. Now, let me give you an example of some research that shows how this works. In the States, there was a study done where they gave 3 different groups of lawyers the exact same case file. And they asked the lawyers in each group to say, can you please make an estimate of who will succeed in this case? I think it was a personal injuries case. Who will be the winner at trial? And what will be the damages awarded by the judge, if any? Now, the 3 groups all had exactly the same information, but one group came up with an estimate of success and an estimate of damages that was significantly higher than the other 2. One came up with one that was much lower, and one group was in the middle. What was the difference between the 3 groups? The higher group was told they were acting for the plaintiff. The group with the lowest estimates was told they were acting for the defendant, and the middle group wasn't given a role. They were just asked to make an estimate as a neutral. So you can see that just the mere fact that they're acting for the plaintiff or the defendant changed their estimate of the likely success of this claim. Now, that's based around confirmation bias. We have a tendency to notice things that support our own understanding or desire for the case. And we have a tendency to skip over or make excuses for things that don't support our case or not even notice them. And all lawyers, all humans, are affected by this bias. So that's one of the reasons why we also can see an overconfidence bias in lawyers. We know that lawyers generally are more pessimistic than the general population, but when you give them a question to estimate their prospects of success, they tend to be over-optimistic. And typically in a mediation, I'll ask each party what their likely prospects of success are. And if I add them up, they're normally about 150%, at which point I say to the clients, which one of the lawyers is wrong? But we do get overconfident because we're subject to this confirmation bias. So it's something to be really mindful of. And, once again, how do you avoid the confirmation bias? The answer is it's really difficult. It's programmed into our brains. So unless we're actually deliberately putting ourselves in the shoes of how would I run this case if I was the other side, or maybe get a junior on your team to say, you're not researching for us, you're researching for the other side, that's probably the best technique to avoid this problem. The other thing I will say in terms of standards is how we couch offers in a negotiation. And one of the things that's really important is when you're putting an offer on the table, it's much better to explain how you've come at that offer before you put it on the table. So in all my rent relief negotiations, I will normally help the parties put together a spreadsheet, and we actually walk the other side through the spreadsheet going, this is our assumptions that we've put, this is the calculations that we've done. And on that basis, this is the offer that we'd like to put forward to you. The reason I do that is because, once again, we're programmed to listen to reasons. We're more likely to be influenced when we're given reasons for doing something. But also, it's about the reaction I'll get from the other person. If I've stepped through the reasons and got to an outcome that they don't like, they've at least heard that and got to that stage. If I give them an outcome that they don't like without putting the reasons first, chances are their internal dialogue is now going, what a crappy offer, that's ridiculous, who do they think they are? And they're no longer listening to anything that I say. So building up to an offer, particularly if you think it's an offer that is not going to be acceptable, will help you move that negotiation forward. It won't get you necessarily a guaranteed acceptance of the offer, but it will minimise the amount of resistance that comes up. Okay, the last piece is subjective anchoring, and that's really about whether you should put the first offer on the table or not. I get all sorts of views about this. Some people say they always like to put the first offer on the table. Other people say, no, I want them to put an offer because I want to see what the ballpark is. Where are we up to? There is research to suggest which of those options is best. And basically, if it's a case where there is a fairly clear expectation of where this negotiation should land, then putting the first offer on the table at an end of that acceptable range that is favourable to you is the way to go. If there is no information, if it's a lot more uncertain, then getting an idea of where the other person sees this and getting them to put an offer on the table first can work better. Given that the timing, I won't go into that more, but if it's something that you're interested in, I've got a blog post on that. I'm happy to share that with you. Alternatives. This is another really critical one in every negotiation, and particularly in mediations. This is really about what happens if we don't get a deal done. Now, interestingly, the strength of your alternatives, how well you can meet your interests without the other party's involvement in the process, is where a lot of power comes from in negotiations. And I always think my favourite story about this one is a battle between Coles supermarkets and Campbell's Arnott's. Now, Coles and Woolies both have reputations as being pretty tough, difficult to deal with negotiators, and pretty good at getting their way in a negotiation. What happened a few years back, and I think it was in 2016, was Coles sent a letter to Campbell's saying, we are going to put a 10% price reduction on 50 of your product lines, starting in about 3 months' time. Now, if you were a little supplier to Coles, you probably would just have to roll over and accept that, because what are you going to do if they don't keep stocking your product? They're probably a major customer. You probably don't have a lot of other places to sell the product. And so you're not going to have a lot of negotiating power when Coles comes, because they can just turn around and say, well, you know what? You accept the price decrease, or we'll just take your product off the shelf and we'll replace it with someone else who's knocking on our door trying to get on the shelves. For Campbell's Arnott's, though, they stood their guns a little while. So this actually made it into the press. It was quite big at the time in the press, and they were able to do so because they looked at their alternatives. So once again, what would Coles do if Campbell's Arnott's took its products off the shelf, if they refused to do the price increase? And one of the clinches for Campbell's Arnott's is one of the main products that was in this group of 50 was Tim Tams. And so Campbell's Arnott's was pretty comfortable that Coles wouldn't want to not stock Tim Tams. They were also pretty comfortable that if they did not stock Tim Tams at Coles, that customers would be willing to go to Woolies or IGA or somewhere else to go and get their Tim Tams, and they'd probably do some of their shopping there as well, which would be negative for Coles. So because they had a belief that the alternatives, if no agreement was reached, were not going to be harmful to them and were going to be more harmful to Coles, it gave them a position where they could stand up in the negotiation and hold firm. So in the end, what happened was 40 of the product lines stayed at the existing cost, and Coles dropped 10 of the minor product lines. But once again, how does this relate to your negotiations and mediations? When I'm mediating, again, in the private sessions, one of the key tasks that I'm doing is looking at people's alternatives. Now, in a mediation scenario, the alternative is generally litigation. So I'm actually getting up and doing spreadsheets of what is going to happen. What are your prospects of success? If you win, what's the likely amount that you'll get paid or you'll be able to take home? What will be your out-of-pockets for litigation? How much will you possibly get back? What does that look like? What's the percentage of this happening? Then I'll go, what's the worst case? Let's have a look at you lose. If you have to lose, or if you lose, what are you going to pay the other party? What's it going to cost in your legal fees, their legal fees? What's the percentage? What's a more likely outcome? And we can actually come up with a sort of weighted average of these numbers to help people work out what is a commercial amount to accept today based on the risks of litigation and the costs of litigation to enable them to walk away today. And once again, because you've got that very structured approach to that, it can really help them see the comfort. Even though they're not happy with the outcome, they can live with it. And that's what I'm always looking for in a mediation, is an outcome the parties can live with. The power of visualization that I've put there on the slide is really about the fact that lawyers often have these discussions with their clients prior to the mediation. They talk about costs, they talk about risks, but it's only when they see the numbers on a spreadsheet that the clients go, ah, and it can really just help them get it when they see that in black and white. So it's a really useful process to go through, and there's no reason you can't do that with your client before a mediation. So the alternatives are important. Next is commitment. I talk about commitment in negotiation and mediation from a couple of perspectives. The first is that timing is everything for mediation. And you might have heard people talk about mediations, disputes being ripe for mediation or not. And this is about getting the process right. If you mediate too early, where there hasn't been any information shared between parties, there won't be enough information for them to get to an outcome at the mediation, and you'll probably fail. You might progress the negotiation. You might have actually helped through that mediation process to move them towards an outcome. But if your mediation is just a 4-hour, half day or full day mediation, and more of it's about figuring out what information needs to be shared than actually working to the outcome, you probably won't get a final outcome. So there's a couple of things there. One is you can look at mediation processes which are more fluid than that actually see the mediation process being a process of helping the parties. So you might go, okay, step one in the mediation is to get the parties together to work out what needs to be shared. Then we'll come back and have a second go to actually try and get to an outcome. If you leave the mediation too long, though, the parties will have the information that they need, but in the process, they'll have spent thousands and thousands of dollars and hours of their time on this dispute. And that creates a psychological interest, which is in getting, I use the word revenge, but it's not necessarily seen as revenge. But people now have an interest in actually sticking to their guns because they've already invested so much in the process. And it can make getting to a settlement that much harder. And the number of times I've had mediations where they've agreed on the substantive issues, but the mediation has fallen over in the end because they could not agree on what would happen in relation to legal costs incurred to date. So trying to bring the mediation as early as you can, but making sure that you've done the work to have the information needed is a fine balance and something you need to really think about from the beginning. That being said, in any negotiation, don't just wait until the end of the negotiation to get agreements in place. Use process commitments about how you're going to take each step to try and move the parties forward to see that there is some agreement possible. So it might be, well, we're not agreeing on a final outcome, but we'll agree on who a mediator is. We'll agree if a mediation is a useful process. We'll agree on how we'll do valuations for a business dispute, for example. So we'll agree on those processes and try and make some of those processes mutual rather than unilateral. Let's agree on a joint valuation rather than two separate valuations. Those sort of agreements can help lead you towards a more collaborative process. All right, a couple of other key tips that I want to talk about in relation to mediation specifically is the importance of a pre-mediation conference. So when I do mediations, I will always try and meet with the lawyers and their clients before the mediation, and I'm doing a couple of things. I'm priming the client to make sure that they have all the information that they need to be able to make a solution on the day. But I'm also starting to get them thinking about where the boundaries of settlement might lie and starting to move them. So if you think about negotiation, I'm here, which is at disagreement. I need to get to here, which is agreement. I'm trying to bring them a little bit closer before the mediation day so that they don't have to move as far. So I'll get them to start thinking about their alternatives. I'll get them to start really digging into what their interests are at a pre-mediation conference. So some of the work is already done on the mediation day. The other thing that can make a difference in the mediation is the opening statements. What gets in the way is probably opening statements that are too legal. There's not a court of law. I think it's important that the key issues from a legal perspective are discussed, but ultimately something that focuses more on the commercial interests and the needs of the parties that will help us come up with outcomes in the day will be more productive. And the other thing is, of course, you'll get to stalemates in a negotiation from time to time. Now, that's where one of the powers of mediation comes in, because as a mediator, there's a number of tools in my toolkit to help get past stalemates, whether that's a mediator's bid, whether it's putting offer ranges on the table. There's a whole bunch of techniques that I can use so that where a negotiation with just the parties might stall, the mediator can keep that moving forward. So that is the majority of what I was going to cover. And I think there's a few questions in the question box. Are there, Emma?
I'm just about circulating the slides afterwards, which we can absolutely do, and sharing that blog post on the offers as well.
Fantastic. Yep, great. And then I have a question that's come to me. How do you find the negotiation process during lockdown? Are there any things or tips that work while you're not able to have direct physical contact with the parties involved? So look, it's interesting. So I've been doing all of my negotiations and mediations virtually since lockdown started. There is obviously a difference in face-to-face communication versus online. That being said, I've found that mediations certainly have been working very well online. I do try to make a few things as ground rules. And one of the interesting things is the two mediations that I've had this year that haven't settled, both have been situations where one of the parties were all physically present in a single office. So I had one where there was 2 lawyers and 3 clients, all on the same side, sitting in an office. On the other side, I had a lawyer and a party who were on separate Zoom screens. So one of my Zoom screens had these 5 people, but I couldn't see everyone at the same time. In fact, most of the time, the laptop was pointed towards the solicitors who were on the opposite side of the table to the parties. Now, for me as the mediator, that made it really difficult to get to a settlement, and because I couldn't engage directly with the clients. So a lot of the time I'm talking directly to the clients, and making sure that you can do that through the technology is important. So overall, virtual is just as good as face-to-face if you know the parties. Certainly from a mediation perspective. From a negotiation perspective, it's slightly different because the mediator fills in the trust gaps that might exist in a negotiation, whereas if you don't have that mediator, it's a little bit harder to build that trust. The other thing I would say about virtual is just be careful, because a lot of what we do then is via email, and the risk of miscommunication and escalation of conflict via email is quite significant. Rachel's asked, what is a mediator's bid? So sometimes if you've got really close to an outcome, there's a few different ways that can work, Rachel, but it might be if the parties have got very close, but they're just not quite getting to an agreement. One of the techniques that I might use is say, okay, well, what I'll do is I'll put a number in between those two and I'll give it to each of you. If both of you agree to it, we're done and we've got an outcome. If one of you or both of you don't agree to it, then we walk away and we call the mediation closed. So that's just one technique where the parties are really close, and I wouldn't use it unless they were extremely close, but that's one example of a mediator's bid. Deborah's asked, do you have a preference for who makes the opening statements? Okay, and she's then said some mediators have insisted the parties do it and others where they want the lawyers. So there's 2 elements to that. So the first thing I'd say is generally I'm asking the party who has called the mediation to start. I don't have a preference for whether it's the lawyers or the parties who speak. I will involve the parties in conversation over the mediation, but I'm not going to force a party to speak who's not comfortable doing so, because for me, I have to have the trust of all of the parties in that room. Every lawyer, every client has to trust me so that I can do my job. If I make them uncomfortable, then I'm not going to be able to do my job well. So if a client doesn't want to do an opening statement, that's okay, but I will direct specific questions to them through the mediation in a way that makes them feel comfortable. If that's not working, I'll take them into private session. I'll have a chat about what's important and what's going to help the mediation and see if I can get them to be more comfortable engaging in that way. But, you know, once again, I think for me as the mediator, to force somebody to do something they don't want to do is not going to create a relationship that helps in the mediation overall. Thanks for that question, Deborah. Any other questions?
I just have a question. Hi, my name's
Abby.
As a young lawyer, I occasionally, especially we work in family law as well as other commercial stuff, but occasionally I'll be negotiating just with the other lawyer, say at court, and it's just, you know, one-on-one with that lawyer. Occasionally I find it can get tense, or sometimes an older, more experienced lawyer, it feels a lot, there can be just like attitude in the voice and a lot more aggression sometimes. And I just would like some tips on how to deal with that, because I just don't engage and I just try and get back on track. But sometimes it can really affect the negotiation for the parties. And, you know, we're there for the parties, not for our egos. So I just want some advice on that.
Yeah, thanks, Abby. And that's probably one of the most common questions that I get from, particularly from junior lawyers. There's a couple of things. I think, you know, firstly, what you're saying that you're doing already, just staying calm and staying focused on track is obviously the number one. Asking them for more reasons. So particularly if they're being unreasonable, I would be asking them for, you know, to back up. So why do you think that would be good for my client? You know, if this was your client, would you expect them to accept that? So, you know, putting that sort of, put them in on the other foot can be helpful. It is important though, you know, if the person who's doing this is the sort of person who likes to play their ego, it's really important to not destroy their ego or try and damage it, because that's just going to make them more aggressive. So that's a sort of short answer. It sounds like you're on the right track and just keeping it practical and asking them questions. You know, once again, just keep asking them, why is that? You know, give me some more examples. You know, it doesn't seem to me that this is the sort of thing that you would generally recommend to a client. Why would I expect my client to want to do this? Just going back and putting more questions on them can be helpful.
Yeah, okay. Thank you for that.
Thanks, Abby.